Welcome back to another episode of Trial by Media, Fair or Foul, where we finally jump in to the media and talk about what rights they actually have and why they file motions to intervene on these cases, why they act like they're a party to these cases sometime, or they have some right to be sitting in the courtroom and broadcasting it live for the world to watch. Do they actually have any right to do that? Or is this a system that's new, that's just come into place, that might be shut down before it ever really gets going? And to help me answer that question today, I've got my dad, George Tragos, and our associate, JD Patel. So to kick it off, where does the right that the media even can sit in this courtroom, can report what's happening in the courtroom, can maybe record it and stream it out, where does that right come from?
Well, you've got to go back. Actually, the rights start from common law, where we had open trials, where they tried to have open trials even before we had a constitution. And then we have the freedom of the press in the First Amendment. Then we have the Sixth Amendment, which is an open trial. And then it moves into the Supreme Court ruling. And actually, the Supreme Court ruling didn't really happen until 1980. And in 1980, in the Richmond newspaper case, they actually said that the courtroom has to be open to both public and the press. And that's where it really came from. It started in 1980, although it came historically, it was always that way, but there really wasn't a court decision that codified it till then.
So I think it's important to have that distinction, right? Because we always talk about public access, public trials. It can get convoluted sometimes that the media is supposed to be reporting to the public and helping the public understand and see the process, but it's actually two separate things, the public and the press.
Right.
So why is it necessary to make sure the press has a right to be at these trials?
So part of their thing initially was to help ensure transparency and accountability with the government. And that was their ability to teach the public how to do that. And as it kind of transpired over time, the public got the opportunity to learn about the legal system through the media. And that's kind of where it is now. It's really big that the media is able to teach the rest of the world how the criminal justice system works and to keep everybody informed of things like that.
So, Dad, how do you think that's worked over time? So that was the initial reason to allow the media in, to have access, the press to have access to these trials, to then report it out and help the public understand the judicial process and teach them about the judicial process. Do you think that is how media took it and ran with it?
Yes. Oh, I think it's definitely worked, because
worked.
Yes, it's definitely worked, because what distinguishes our country from so many others is a free judiciary and a free press, which makes for a free society. Because if you look at any other countries, the first thing they do is suppress the press. And when they do that, they lose a free society. So it's definitely worked in our country. I don't have any doubt about it.
Except for the fact that people think that that's happening in our country now. And I think that's the point, is that it has happened in other countries and people fear that it's happening in our country, or that, mainstream media is biased one way or the other, or for something or against something. And I think people don't realize the freedom of the press and the fact that they are free to have people with certain ideologies come and explain this to you. And you have different channels with different ideologies and different people that explain it to you with different ideologies. That is the point of free press. And I think as long as the facts are reported appropriately, how someone may think those facts point is no different than a jury seeing the same fact and two different jurors maybe taking it different ways, or thinking different things of a specific person testifying. And that's the point of the media, right? So they can explain, oh, this person did great on the stand. Another person may report they bombed on the stand. That's the same way two jurors could think of it. So that's kind of what the free press looks like. And thinking that it's worked to keep our country free. Talk about a little bit the media's involvement in these cases and why sometimes they get to file motions to try and make sure that their rights are protected. And it's not just the two parties and the court determining what's going to happen in a case and who's going to be inside the courtroom.
Well, it's the press has their own right. The courts have recognized that they have special protections. And therefore, when for instance, gag orders, those kinds of things come up, the press can go and challenge those gag orders, even though they're not a participant in the trial, because the courts have recognized they have a special status and they have standing to challenge those. So that's why they can do it.
So
But
it's not like it's not different than any other case where somebody's rights are affected by this case that's going on. You can file a motion to intervene. You can explain to the court why this is affecting your rights. And if the court thinks that it is, then they'll let you come in and make your argument or make your motion. Now, it just so happens that the media's rights, like you said, are affected in all these trials. So they file this motion to intervene, and 9 times out of 10, the court's going to let them make their argument and make their motion. Doesn't mean they're going to win, but they almost always have a right to intervene in a case and have their side heard. And, a very high profile case where this is happening right now is Brian Coburger in Idaho. And the media has made multiple arguments to try to get rid of a gag order. There is literally happening at the same time we're recording this podcast this week. The media is going to have their hearing and try to keep cameras and microphones in the courtroom because Coburger's team, the defendant in the case, and the prosecutor both basically agree, let's get cameras out, let's seal the doors, let's seal all these documents, let's not have a public trial here because we're affecting the defendant and the prosecutor's rights, which we've explained on other podcasts. But the media is now intervening again, making their motion and making their arguments. What arguments do you think that they're going to rely on based on what people have relied on in the past, JD?
Well, I want to touch on one thing first before I
Okay.
address that, and that's the Supreme Court's essentially ruled in multiple times in the state of Florida, Supreme Court of the United States, that the media doesn't have a right to be at every single pretrial hearing. So, and that's big because a lot of evidence that may be excluded, included certain things that may not appear at trial, will come out during these pretrial hearings. And what the court system is supposed to do is to withhold that information in that sense and not let it get out, because it could affect the public's perception of what should come at trial, what shouldn't come at trial. There's certain types of hearings that are basically protected from being recorded, like Williams rule hearings where there are other bad acts.
I want to talk about this, but this is kind of further down the road. So just specifically right now, what arguments does the media usually rely on when they intervene to try and keep cameras, to keep microphones, to keep their access to report what's happening in these hearings and trials, whatever it may be? And we can get to the nuance, the differences between trials, the verdict being read, which we've seen happen in some trials where the entire trial was not live streamed, but the verdict was, the sentencing portion, and why there might be some nuance there. But just as an overarching theme, when the media comes in and tries to fight against gag orders and courts kicking them out, kicking their cameras out and their microphones, what kind of arguments do they make to try to stay in and report what's happening inside that courtroom to the public?
Sure. Yeah. It's that they're not overstepping and violating the defendant's Sixth Amendment right to a fair trial. They're not disrupting the court proceedings. There's no effect on the jury that would cause them to sway one way or the other, feel pressured. It's not like the old days anymore where, cameras are clicking and a lot of noise is being made. Everything's kind of more secrete at this point. And that was a big thing that used to play a part back in the day. Now the media is being able to argue that, we can record this and be present and it not affect anybody and not affect the proceedings. So that was one big argument they can make.
So, Dad, and also in addition to that they're not going to violate any court order that may come down where the court says you can point the camera here, or you can only stand there, or you can't have high sensitivity microphones, whatever it may be, the least restrictive means necessary to still have freedom of the press and reporting to the public. But if the response to that, Dad, is like in Coburger, we're using an example since it's happening right now, but it's not uncommon for this to be the argument. Well, you're doing things that have nothing to do with the purpose of the press being there, which is, again, to teach and report to the public what's happening in our judicial system for transparency and honesty from everybody. So what is it when the response is you're taking pictures of, Brian Coburger's fly being down, or whether or not Lori Vallow is wearing makeup, or making comments on things that have nothing to do with the case? Once it becomes entertainment value, or like the Coliseum in recording these cases, what responses can the media have to that may be legitimate in where they're making these arguments that they should still be allowed to be in the courtroom?
Well, because what they're saying is it's prior restraint. In other words, you don't have the right, Judge, to say what the public wants to see and what the public doesn't want to see. They have a First Amendment right to see these things. And we, as the media, it is our duty to show the public everything that's going on in the courtroom. Now, that may fly or not fly, but that's their argument, is that whatever happens in the courtroom, the public has a right to see it.
Yeah, but I mean, I think the judge can understand how, or can make kind of discussion points about how that affects the
sure.
defendant negatively. But but I do think there are some legitimate arguments, right? But for the media, in that they have a right to report this stuff. Just because they take a picture and you can see Brian Koberger's fly doesn't mean that they're reporting on that, right? And I do think that there's a difference is the media reporting versus what somebody else in the public looks at and makes a joke about or talks about in a picture is very different. So talk a little bit about, Dad, how if the media reports, based on this hearing, Brian Koberger seems really guilty, or maybe the defense does have a point poking holes in this argument. To me, that does kind of, regardless of, how I feel about it, and I try not to do that, but there are some media people that will do it that way. How is that any different than reporting what's going on, teaching people how the judicial system works, teaching that this evidence points towards guilt, or poking these holes points towards a not guilty verdict? Why is that not allowed by mainstream media to report on guilt and innocence and things like that, and their feelings and thoughts based on what they hear and see in court?
Well, I think you've got to, again, historical. The press used to just report the facts and not give opinions and not editorialize. That's the way the newsroom used to work. Now you have newsrooms that are also entertainment. And so you have a newsroom now that gives opinions. I gotta be honest with you, though, I think they have a right to give those opinions. It is. They have a First Amendment
part of
right.
the freedom of the press.
That's right, part of the freedom of the press. It's just that people now are more opinionated than they are just reporting the facts. And that's what's happening, is that they're changing the scenario. They're looking at, all right, they want you to view it a certain way, so they're trying to influence you rather than just reporting the facts.
And JD, as that goes back to when you're saying, the media is supposed to teach the public about this stuff, they're definitely not experts. For the most part, there are some people that in media that are experts, or that are trial lawyers that go on mainstream media shows or whatever it may be. But just somebody sitting in the courtroom as a journalist saying that somebody's guilty or innocent, there are obvious problems with that. We've talked about them so many times. I talk about them on basically every show and podcast. I talk about how you can't condemn somebody in the presumption of innocence. So we know how important that is. But as far as people being able to share their opinions on mainstream media, how much of an effect do you think it has on the potential jury pool? And is it not like anything else having an effect on a juror? The family members they have, the shows they watch, the news they watch, it's going to have an effect on how they think about everything.
I mean, I think it does. It will have a pretty big effect. I mean, just by the nature of how technology's progressed, and how, I guess, how easy access to see these kinds of things. Like, take so many YouTube channels that are commenting on it. The popularity of these things, of crime shows, all of this, people are going to listen to it. People are going to want to pay attention to it, especially if they're in that area. But I think that's the lawyer's jobs at the end of the day, to kind of piece those people out of here. And, during jury selection, have you listened to stuff like this? Can you be fair and impartial? I think that's going to be their biggest job, and it's going to make the job a lot harder, I think, because some people may want to, be famous because of it, and get on that jury.
We have a, example. We all remember the O.J. Simpson trial, no matter how young you were during the time. When I was trying cases during the O.J. Simpson trial, you had to spend an inordinate amount of time in a case that DNA had nothing to do with the DNA. But because O.J. Simpson had the DNA as front and center in that trial, you had to talk to jurors about DNA over and over again, because they were looking for DNA in every single criminal trial, because that's what they heard about on television.
Yeah, no, I definitely think it affects the process, but I think there's got to be a balance to where we don't just hide it because people are going to see things differently, but we find better ways to report it. And I mean, I do think that maybe when it comes to the justice system, it wouldn't be a bad idea if the rules of ethics were just, you can only report facts and not opinions, period, as a reporter, or as somebody in the press, and then talking heads can talk about whatever you report. But I mean, that's just how the world is. So I find it very weird and, almost like intellectually dishonest to think that we can't give our opinions about what's happening in the court of law in the communities in which we live and may find ourselves a party to at some point in our lives, and how it doesn't benefit us more to actually know what it's like and not hide the ball and not make it such a scary process that can be used as leverage by one side or the other.
Well, this,
I think it's important to talk about the crossover, though, into the press and reporting and media access, and how far that access actually goes.
well,
So where does
this
it go as far as the case law, and how is it defined as far as cameras, recording, audio, live streaming? Where does that stuff come from? And is it just going to continue to grow forever as technology changes?
this is not a new concept, and this is not a new problem. And you remember, you guys are a lot younger than I am, but in law school, we all heard about a famous intellectual judge called Learned Hand.
Mhm.
And Learned Hand, back in 1942, before television, said, "The hand that rules the press, the radio, the screen, and the far spread magazines rules the country. Whether we like it or not, we must learn to accept it." So we're not going to change it. It's only going to get more and more pervasive. He never thought of social media when he said this, I'm sure. So we have to accept it, and we just have to learn how to deal with it. And courts are always slow to deal with new technology, and we just really have to learn to deal with it.
But
I
how does
think a lot of
case law
it's
like define it, JD, as far as even back in old cases, when did it go too far? When were lines crossed as far as the media that, parties can try to use now to say that they've gone too far with these high sensitivity microphones and these cameras that can zoom in and whatever it may be, as far as crossing the line, getting too invasive into the process?
absolutely. And there was a case that I talked about on the prosecution episode. It was Shepard v. Maxwell. It was a murder trial, and essentially the media was all over the room. I mean, they were past the bar. They had about 20 reporters in the room. They were zooming in on both parties. The counsel and his client couldn't even talk properly without, media being involved and listening in on it. And they basically said at the end of the day that, the erection of a press table for reporters inside the bar was absolutely wild. And they ended up reversing some issues because of that. So the problem is it's all after the fact, though, and now we're learning what's too much. And I think George is pretty familiar with one case, Estes v. Texas. That was, he can talk about that one as well.
Yeah, there were at one time reversals based on press. Estes was reversed. Shepard was reversed based on the press coverage and how the press handled it. But that all changed in a case called Chandler versus Florida, and where the Supreme Court kind of changed their attitude toward the press. And it became almost impossible to reverse a case now based on press coverage. And then you had the O.J. Simpson trial. And, who could have had more press coverage than that O.J. Simpson trial, where it was live every day, all day, and people were glued to the screens. And now we see that happens all the time with trials. And yet the courts are not reversing based on that coverage.
What's interesting to me is it does sound like in these cases, and that Shepard case is one that was cited in the Coburger discussions here. But what's interesting to me is it sounds like, as we look back into case law and they talk about the press and how the press affected the process and made it unfair, it was really about interruption and making a mockery of the courtroom, making things more difficult with the sounds, with the wires, with the press table, and how it just wasn't really a trial anymore. It was like a circus. And even in OJ, they were talking about that, like the press at the courthouse doing all this wild stuff. That was even an issue in Johnny Depp's case, people lining up around the corner and the jury, knowing about that or seeing about that. But it's kind of morphed today. And I think the political climate, the division in the country, the way the talking heads try to be a certain way on mainstream media, I feel like the argument has morphed into they're convicting somebody before the trial even starts. The opinions are swaying and poisoning possible jury pools. But back in the day, Dad, weren't news articles and newspaper articles written the same way, where when they would write about some accused killer, I mean, they would convict him in a newspaper article too. And that wasn't necessarily the same argument they were making that was successful, I should say, in overturning certain verdicts because of the media attention, was it?
Well, no, it's what happens in the courtroom. And I think you hit it when you said the way things were going on are being conducted in the courtroom. And that's the difference. judges have to control the media in their courtrooms. And when they go out of control, that's when you have a problem. That's when you don't have a fair trial. What you're talking about took place outside the courtroom. And therefore, the trial itself shouldn't have been affected by it. But it's what judges allow in the courtroom that makes the difference.
And that's the point. And now they can be more conspicuous with just 1 or 2 cameras. They can just put the small high sensitivity microphones that you can't even notice are there, which we already have microphones in the courtroom. People have talked about, courts getting their own system of cameras and microphones to make it easier and not have that problem. But again, it does seem like the parties in the court are trying to control people's opinions outside the courtroom, which I understand to a certain point. But I got to be honest. In most states, these crimes and charges are public record. In most states, these documents are publicly available. So whether or not the media is in the room, mainstream media, YouTubers, social media, if they really want to dig and get the documents, they can put them up on screen. They can give their opinion. They can convict somebody just as quickly with a picture and just the charge. He's charged with these 4 counts of this heinous crime. Look at this guy. When they arrested him, he must have done it. Look at his booking photo. Look at his mug shot. He must have done it. I mean, that stuff's been public record forever. And honestly, the live streaming and the cameras and the microphones, to me, can give more insight and information that might sway people in a different direction than what they would think just based off a probable cause affidavit and charges that they hear in somebody's mugshot. Don't you agree?
I agree with you. I do. But again, how do you regulate that? How do you have a free society and then regulate the press? It's really a very difficult decision. Courts have trouble with it all the time.
What do you think, JD, about the difference between like what's happening in the courtroom and out the courtroom, and how much control really the judge or the parties in that case can have over that?
Well, you made a comment about, the cameras being in versus not. And I want to touch on that real quick. And it's because there was a federal case that basically said the ability to see and hear proceedings as it unfolds is a vital component of the First Amendment right of access. And one cannot transcribe an anguished look or a nervous tick. So there was a case here in Florida back in 2014 where the media was not allowed to sit in on jury selection. They were in a room next door listening to audio only. And they did a motion and they won that motion, basically saying, no, they have a right to be in the room present. So being present in the courtroom is just as important to them, because you can see the demeanor, the body language, the nonverbal expressions. You're not going to get that just by looking at documents. You're not going to be able to see any of that kind of thing.
Right. But my point more about the documents was people can go ahead and make their opinions and make crazy TikToks and convict people with just documents. They don't need to have the live stream, but the cameras and the microphones, again, give us that access that's so important to transparency. And that's the point. We have to keep everything has to be under the cover of there's a reason that our country wrote the laws this way and wanted freedom of the press and wanted the public access. They did not want things to happen behind closed doors. And some people that are all for that, frankly, I mean, it's my generation and younger even, they don't remember or even think about what it was like back in the day when there were less rights. Like every generation that goes by where there's more and more rights and more freedom. I mean, people maybe think it's going the other way, but when you think at least about countries past and even countries currently that just don't have the freedoms to even understand what's happening, or one dude makes a decision and there's nothing you can do about it and you don't even understand how it got from A to Z. And that's really what we're protecting against more than anything else with the press. Whatever people want to say about mainstream media, whatever they want to say about the press and the angles and getting clicks and the money and the clickbait and whatever it is, the point is the purpose of having them there is for transparency, to keep things fair. And with that in mind and kind of that overarching theme, they do have a duty, right? The media has a duty, and there are repercussions if they lie or misstate facts and just kind of shade something in a way that is just not what actually happened. And I think that the cameras and the microphones also aid in that, right? You can't just rely on one reporter coming out and saying this is what happened. People can see it with their own eyes and hear it with their own ears. So how does the duty of reporters and journalism come into play when we talk about whether or not cameras and microphones should be in the courtroom?
Well, first, there is no constitutional right to have cameras or any audio visual in the courtroom.
Right.
There is a constitutional right to the press being in the courtroom, but not to the recording or the cameras. That's not a constitutional right.
Right. That's an additional step of transparency. And so the
Right.
people and the public can actually see what's going on.
Right. The Hastings case said that they don't have a right to have
No
it.
doubt about that.
Okay.
And yeah, and I mean, it's been ruled in other cases where judges have booted cameras and microphones. There's no doubt that there is not an absolute right to that. But why do the laws and the case law and the precedent that's already been set and decided on, why does that point to actually allowing cameras and microphones in the courtroom? And that's usually the default in state court, is to allow cameras and microphones in there unless the media screws it up.
Well, and we haven't, but to prevent lying too. I mean, let's talk about accuracy. For instance, there people, lie, cheat, and steal on some of these media, on some of these social media. They totally false allegations. They say testimony that didn't happen, or things that weren't admitted into evidence. They heard at the hearings JD was talking about there that never got into evidence, yet they're spewing it on social media. And so we've got all these lies. If we don't have the recording, if we don't have that visual of actually what actually happened, then it's much easier to lie and fool the public as to what actually happened.
Especially if there are celebrity parties or political parties in the case and people have agendas. Like, yeah, especially that. Like if I was somebody that was generally hated, I would want cameras to be there so people could see how it actually went. You're not just relying on one news organization or a conglomerate reporting on it a certain way, which is why I think the cameras and the microphones are so much more important than even the press being in there these days, because people can watch and see it before they get it, quote unquote, explained to them.
I think that's big too, because the media's their protection is, it's a qualified privilege, and it's based on if it's only enforceable if what they report is fair and accurate. Mm-hmm. So if what they report is not accurate based on what the documents say, whatever is actually heard in court, that privilege may not apply to them, and they could get sued for defamation, libel, whatever the case may be. But the cameras in the courtroom basically hold them accountable too. It's just like, the enforcement of body cams, right? Now you can actually see for yourself what happened, which is
and not
huge.
just rely on the cop's perception of what
Exactly.
happened. Yeah, exactly. I mean, and everybody's for that. And I think, again, the big outcry, and I understand it and I get frustrated by it, and I've come out and spoken against it, is what people do with the access and the cameras and the microphone can be frustrating, but it's also kind of the reality we live in, right? Like, people have opinions. Jurors have opinions. There may be a juror that looks at the way somebody smirks or smiles or whatever. Dad, we have argued in cases, as I'm sure JD has as well, that we have to be able to see that person's face, see their facial expressions with the masks, with COVID, and how we would fight against having our trial in that period of time. We had to try a case with masks on, Pete and I, and it was miserable. Not only was it sweaty and just harder to do, but you can't see the jurors' faces. You can't see the witnesses' faces. A lot of things change on what you can actually see with your own eyes. And that kind of leads me to, where do we think this is going? And do we think there needs to be some kind of rule change that does protect cameras in the courtroom? Even if it's not, a cinematic effect or high sensitivity microphones, maybe it's just a bird's eye view or whatever it is. Do you think that because we have this technology now, and because we all still want that transparency that was the policy reason and the spirit of this rule from the beginning of our country, because we all still believe in that more and more and more, do you think there needs to be some kind of rule that there will be cameras and microphones in the courtroom so people can watch it, even if it's more like a CCTV feel? Do you think that's where we're going?
Well, Peter, you sit, I know, on the Civil Rules Committee for the Florida Bar. The Judicial Administration rule, there's a 2.450 that actually, we have a rule in Florida governing cameras in the courtroom. And so that a judge can follow the rule and allow a camera in the courtroom under certain regulations. I think that it will be more and more regulated. I think that we will have more and more courtrooms with cameras in them, but I don't think it's going to happen in federal court.
Right.
Because federal court the Supreme Court does not like this live videos. They think it really affects the trial. And I don't think they're going to change the rule because we have judges on the Supreme Court right now. Judge Alito is a very conservative judge. Judge Keegan's a very liberal judge. They both agree that you shouldn't have cameras in the courtroom. And so you're not going to have a change in federal court because they think it really affects the trial too much. But I think you are in state courts. And I think another reason you're going to have them in state courts is because state courts, especially in Florida, those judges are voted on. There is more public involvement in the state court process than there is in the federal court process because they're appointed judges. So I think you're going to have more cameras in state courts, but I think it's a long time before it'll be in federal court.
What do you think, JD?
Yeah, I agree. I mean, I think state court, it's going to be a lot more regulated. And I think that eventually with new courthouses being built and just infrastructure, I think they're going to start changing.
Let me just pause real quick. So when you both have said it's going to be more regulated, which is a very legal term, what you mean by that is there's going to be rules in place to enforce and kind of make some uniformity. Like you can have one camera, it can be right here. Here is the view. Here's where the microphones go. That's regulation, not get rid of it, not remove them, but actually regulation could end up being better because it can enforce that this is the norm. This is where the camera is going to be, which means there's going to be a camera. This is the view it's going to have, which means you have a view. Maybe it's not live streamed, but it's played the next day. Again, it's not live, which, people like to watch it live, but at least you're going to be able to watch it. It may just be the next day. So regulated means there are rules in place, that can be some uniformity or it can change from jurisdiction to jurisdiction. But at the end of the day, if you have something that's more regulated like cameras, in this instance, it may mean more cameras and more videos and trials being streamed and hearings being streamed to watch and to listen to than less. It could actually mean more, right? When you say words like regulated.
Absolutely. Let me ask you this.
Sorry, I interrupted you.
Do you think jurors are going to want to know, like, if there's a hidden camera that's all being publicized? Do you think that they'll think one way or the other if there's not an actual camera and media being present in the courtroom? Do you think it'll change the way they think?
I think that the norm is going to be jurors are not allowed on that camera, or whatever the view of that camera is going to be is not going to be on the jury. I think that's, if I was writing the rules and after talking to a lot of people and talking about this would be something cool to be on like the cutting edge of writing this rule. I would volunteer for that. That it would keep the jurors out of it completely. And you would only partially be able to see the defendant. It's not like it would be something that's focused in on the defendant's face and maybe having one face the judge and the witness and the other face the defendant and the prosecutor. And that's basically it. You can see the podium in that view and it just is what it is. And that's what you can see, but it's not exactly one bird's eye view where you can't really see anything. But yeah, I think jurors would want to know, would have a right to know where the camera is. And I think jurors should have a right to maybe say, I don't want to be on the camera.
I mean, that's exactly what we have at the state attorney's office here. We had CCTV. So from our office, I could look at one picture. It would see the judge and the witness. And if I flip the channel, go to the other view, it was both counsel tables.
And it's basically green box. And like not like the best camera, and
it was
best
clear.
Picture.
It was good. It
must be getting better because when I was there, it was like green. It was not good CCTV. But I do think that that's exactly what it could look like. And that's what I picture in my head. It's like what's already in place basically at some state attorney's offices that you can watch just internally. It doesn't go out to the public and go out everywhere. And again, they say part of that is to learn and to keep the process transparent. And so the older assistants can watch the younger assistants and critique them and see how judges are working. Because again, they're elected. And I think it's all mostly positive, right? I mean, what are your thoughts about media coverage and about cameras in the courtroom and microphones in the courtroom? Is it generally positive or generally negative?
Well, I don't think there's really a problem with cameras in the courtroom, as long as they're not obtrusive. If it's a very obvious camera where you got a cameraman standing there in the corner operating the camera so that it, really draws attention to it, then it can affect the trial. It can affect the way a witness testifies. But generally speaking, I'm for the public having access and seeing what's going on. I'm also for the judge having discretion, which the judge does, where he can turn the camera off under certain circumstances, or he can turn the mics off under certain circumstances. I think the judges should maintain control of the courtroom and maintain control of the audio visual in the courtroom. But I'm in favor of it generally.
And
what about you,
there is
JD?
case law out there that, I'm completely supportive of what George said. There is case law out there that allows the judge to do that, but they have to back up what they're saying. There are cases out there that say, what the judge wrote in his order wasn't enough to close off the camera. So they basically reversed it. Obviously, it's kind of a post, it's too late at that point.
Right.
But basically it sets the precedent for future purposes. Like, all right, judge, if you're going to, shut down the cameras at this point, you better have a real good reason why. And this is going to be, you better make it in writing.
Yeah.
I
And
remember.
I think, go ahead.
Go ahead. There was a judge, I remember that on the CCTV in the Sixth Circuit in that courtroom that would never let the sound be broadcast to the state attorney's office, that you could see the picture, but you couldn't hear what the judge was saying. He didn't want anybody up there to listen to what he was saying.
It's really helpful. Yeah, that was really helpful of him. I think that it's a really interesting discussion. I hear and understand arguments on both sides, and I really wish people would do better with, the benefit and privilege that we're given of being able to watch and listen to these hearings and trials. Before we get, so that, the last question I'm going to end on is just based on what you know about the Brian Coburger case up in Idaho. What do you think the decision is going to be and why? But we're going to hold that till the end. Because I do want to hit on what JD brought up earlier. And we're talking about cameras in the courtroom, we're talking about microphones, and the major argument against it today's day and age is not necessarily that it impedes the process or is distracting, but instead the media twists it or it poisons the jury pool. Do you think that one way of fixing that would be to remove cameras from the hearings like JD talked about, where the public gets access to things that are inadmissible, that are not coming in court? And although that again may be available in public documents in certain states, some of those arguments and motions to suppress and motions in limine and things like that. Do you think that's a good way to solve it, Dad? Or do you think that then there's no real public access and the entire process is not transparent, because we need to know, did the judge suppress something that he shouldn't have? As the public, how does that work? Why do they suppress things? Why do they limit certain things out? What are your thoughts on it being maybe just at trial and not at the hearings?
Well, I think history has shown that more transparency, even though people scream and yell about how terrible it's going to be, more transparency always turned out to be better. In Florida, for instance, we have a public records law. I remember when that was passed, it was, oh my gosh, people are going to be able to go into all the records and see everything in Florida. Oh, how terrible is that going to be? Turned out to be not terrible. Turned out to be wonderful that you could go in and see the public records. So I think transparency is always good. And I would really be in favor of it. If you're going to broadcast everything you want to broadcast.
Yeah,
Again,
I agree.
Again, there is a public interest sometimes in not broadcasting certain things, and
Right.
I do understand that.
Right.
But generally speaking, I think the presumption should be to broadcast it.
And just to think that like records that are so easily available in public now, you just like couldn't get them before. So like there are cases where you would need something that is there and you just couldn't access it. Just seems mind-boggling to me. So JD, you brought up the point, but what do you think about it? Do you think that's how it should be or no?
I mean, I think that the judge needs to make a call on certain hearings, right? I don't think the media should be allowed at certain hearings because that information may or may not come out at trial. And that's what's the most important part, is what comes out at trial. If they get wind of information that's out there that's probably true, right, but not admissible, and they start spreading that, they're tampering the entire jury pool of that community, right? And whoever it may be. Right. So I think that the risk is not worth it, because at the end of the day, you are protecting. All of this is allowed, the media is allowed, but you can't infringe on the defendant's right to a fair trial. So the judge has to make that ruling and strike that perfect balance between balancing First Amendment rights, the media, and the Sixth Amendment right for the defendant.
Like maybe all 404B hearings should be private, in a closed courtroom, like any prior bad acts or crimes of the defendant. Like maybe that shouldn't come out publicly until trial, because if they're inadmissible and everybody hears about them and reports about them, that's something that I could see maybe creating issues. But yeah, I don't know. I think there's a potential for some judicial discretion in there, although that always adds its own wrinkle. All right. So to finish out, Coburger, the state and the defense both agree at this point they want cameras out. The judge said there are going to be cameras in there for now. They have filed additional motions saying the cameras have violated the court's order. And so has the media, by writing articles that have nothing to do with the actual case, zooming in on Coburger's face, not just filming who is speaking or for judicial education and accuracy, like we're all talking about, and not just watching the proceedings, but they're zooming in for entertainment value. The media has responded to say they did not do that. They were filming Coburger walking in. Other people zoomed in on his fly or whatever it may be. And, they're using it the way that they're using it, but the media is really trying to abide by the court's rules. If they put a camera in a wrong spot, they're happy to move it. So they continue to maintain the fact that they are not doing anything wrong. But what people do with their public documents or videos, that's outside the media's control. So how do you think it's going to come down? And what do you think would be the right decision by the judge? Dad, we'll start with you.
Well, I think that the judge should allow cameras in the courtroom. This is a case of national interest, public interest, and therefore they should be allowed. I do think the judge needs to maintain control of the courtroom and control of the cameras and the angles that the cameras shoot in order to give the public the information about the trial and not about things that have nothing to do with the trial. So I do think that it's going to happen, but the judge is going to have to maintain some control, and it's going to be an effort on the part of the judge, but he's going to have to maintain control. I don't think cameras out of that courtroom is a good idea. I don't think it's a good idea for the public interest or for the Constitution.
What do you think, JD?
I think that cameras will be allowed, and the concerns brought by both parties are going to be addressed, and they're going to be fixed so that these issues can't be raised at a later time. So, he's probably going to end up having just one camera, and everybody can pool off of that. I think that's what it's going to gear towards just in general for high-profile cases, just so you can avoid these appeals in the back end for things that should have been corrected like this, because they've already been brought to your concern. So, Judge, you can fix that by doing one simple thing.
Yeah, I hope you guys are right, because I kind of feel like I'm leaning towards the judge is going to remove the cameras at this point. He kind of gave him a chance, and now that there's an argument that they violated it, another high-profile case in Idaho removed the cameras for the trial, even after having them for some of the pretrial hearing. I don't think it makes sense because the cat's kind of already out of the bag. The toothpaste is out of the tube. People have already heard and seen and listened to and watched way too much of this case to just be unbiased. And now that we cut the cameras off, it's going to fix everything. So I don't necessarily think it's going to work. I wish he would just make more regulations and more rules to where the cameras can be and what they can pick up and where the microphones are. And even if you're, delaying it like they have been doing it, not live streaming it, but filming it and releasing it later. I think all those rules are appropriate and would be fine if he does that. So I hope he leaves them in, but I kind of feel like he's leaning towards booting the cameras. And we'll see if that ends up being an appealable issue. I think we already know they're going to appeal it up to the Idaho Supreme Court since they've already tried to get them involved before. And this is going to be something, if cameras are removed in this case, this is going to be something the media spends a lot of time and money fighting because they're going to see it being a potential problem in the future. And maybe we'll get some more answers. This is usually how changes are made and how laws are changed. A decision is made, it gets appealed, it gets pushed up, a lot of money and power get behind change. And if there's enough public outcry and public pressure, then maybe the rules will start to change in certain states.
Well, just for the Coburger case, Idaho state courts traditionally have not involved themselves in these issues. They have all said, when they said, whatever the Ninth Circuit Court of Appeals, Federal Court of Appeals says, that's what we're going to do. So their appellate courts have been very, very, very reticent to involve themselves in these cameras and audio issues in the courtrooms in Idaho.
So the Idaho Supreme Court already kind of tipped their hand that they think the cameras should be allowed. Right. So I think Judge in that case knows that that's kind of where they're at. And if he's going to have to make certain specific findings, like JD mentioned before, as to why he's booting the cameras. And I think the finding has to be, he feels at this point, there's no way for Brian Coburger to get a fair trial if the cameras stay in the courtroom.
In the other case, they appealed that ruling.
I don't think that they did, but I can't remember. It happened like right before the trial.
Oh, okay.
They had a whole hearing, so they must have fought with it, but I didn't see anything get appealed up to a higher court. If it did, I just missed it.
Okay.
All right. So that's all we've got. Thanks, JD. Thanks, Dad. Everybody, let us know what you think in the comments about cameras in the courtroom, about media attention, because it's really split usually when we do these polls on people thinking, yes, cameras should be allowed, or no, they shouldn't, because it really affects the process. Thanks, everybody, for being here. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.